Hi everyone, my name's Jackson Taylor and I'll be your host today for a session for the Association of Corporate Counsel on what in-house counsel need to know about the immigration compliance. Immigration compliance is something of a sleeper topic, and I'm very excited to be able to share with you today some of the key challenges that businesses in Australia face in dealing with immigration compliance, as well as the penalties, the way the regime operates, and look at some of the steps that organisations can take to mitigate those risks. So without further ado, I'd like to start the slideshow. What in-house counsel need to know about immigration. So what we'll do is we'll start off talking about a bit of background on the immigration program at this point in time. Immigration in Australia has changed significantly over the last 30 years, and that's one of the key drivers of this current immigration compliance regime. And we'll see that the growth of temporary migration, which is people who come into Australia and are here for a limited period of time on visas that often have limited work rights, have really changed the way that businesses need to operate in this space. We'll look at the relevant legislative regimes, which are the charging for migration outcome laws, laws which prohibit employers sponsoring individuals who don't have work rights or who don't have a visa in Australia, as well as some of the sponsorship obligations that organisations who sponsor skilled workers in Australia have to abide by. We'll talk about the scope of liability, because what we'll see is that, in fact, it's not just an offence for the organisation to breach those laws, but also there is potential liability for executive officers. We'll talk about the employer-sponsored visa program in a little bit of detail, just to look at how the sponsorship program works and what the consequences are there for non-compliance. And then finally, we'll have a bit of a chat about mitigating risk, how organisations can manage the risk and ensure that the businesses are on top of things. So moving on. Background: Australian immigration in 2020. Now, the coronavirus has obviously changed the situation in Australia at the moment, but that said, we are still in a very different position to where we were 30 years ago. Now, Australia is a migrant nation, and in some respects it always has been. It's just that in the very early times, pre the enactment of the Australian Constitution and the creation of the Australian nation, and then through the White Australia policy, that immigration was highly restricted and focused on white migration. That changed quite drastically in the 1970s, and Australia has, in the last 50 years or so, become very much a multicultural destination, a multicultural country, and many people would see it as being a fundamental aspect of Australian society. But there's been another shift, one which is perhaps a little bit less known, and a very well-known Australian commentator in this space, Peter Mayers, wrote a book called Indefinitely Temporary, which was about the shift to temporary migration over the course of the last 30 years or so. So up until about the 1990s, virtually everyone who came to Australia for longer than a visitor visa or a holiday came as a permanent migrant. And that meant when they came into society, they had the right to work, they had the right to live here, they were fully functional members of our society. And what changed was that through the 1990s, and then increasingly so in the noughties, and particularly in the last decade, there's been a really drastic shift to the number of temporary migrants who have been permitted into Australia. Now, temporary migrants can be on anything from a visitor visa to a much longer term visa, such as a 482, temporary skilled sponsored worker, which is for 4 years. And there are even 5-year temporary visas. So people may be here for an extended period. And this whole process is also characterised by people moving from one temporary visa to another. So they may enter initially as student visa holders, and then they subsequently move to another student visa, move to a graduate visa, move to a sponsored work visa, and so on. And the net result of that is that many of these people are in Australia for upwards of 5 to 10 years. These people, temporary visa holders, do not necessarily have the same rights as Australian permanent residents or Australian citizens. And in particular, one of the areas that is most closely controlled by the immigration system is the right to work. So, for example, someone who comes to Australia on a visitor visa does not have any right to work. On the other hand, we have a very popular and very large backpacker program, which runs through the 417 working holiday visa primarily. And that allows a large number of people to come from overseas, live in Australia for up to 12 months, which can then be increased to 2 or even 3 years. And during that time, they have some work rights. Likewise, the student visas generally have limited work rights. So they, most student visa holders would be allowed to work for up to 40 hours per fortnight. And obviously, with the differing status of all those people, some 2.1 million people at last count, there are a lot of obligations on employers to ensure that when they do sponsor someone in Australia, they're doing so in a manner which is consistent with Australia's immigration laws. So rather than the situation you might have had 20 or 30 years ago, many employers who operate a larger business, particularly if you're in a sector like horticulture, hospitality, or retail, are going to come into contact with a lot of people who are on temporary visas. And that means that the employers, the organisations, and relevant people in HR, and often and even in in-house counsel, need to understand what the organisation's obligations are and what the appropriate processes are to manage obligations towards those visa holders. So situation has changed drastically in 30 years. And to think that the Australian population is now around 25 million or so, 2.1 million temporary visa holders means that approximately 1 in every 10 or 1 in every 9 people in Australia is in fact a temporary visa holder. So it's quite an interesting thing to think about. And you can see how that change in the Australian demographics has really altered the situation with regards to Australian employers' obligations. Just to look at the background a little bit more, with permanent migration, Australia has let in between 160 and 190,000 people over the last 10 years. But that figure is somewhat misleading because it is talking about permanent migration. So we allow between 160 and 190,000 people each year to become permanent residents. It's expected that this year that number may drop significantly due to the coronavirus, but that's what's occurred historically. And those numbers are split between skilled visa holders, so people who come to Australia on the basis that they're employed by a sponsor because they have skills that are lacking in the Australian market, or on the basis that someone has come through an independent program. For example, a particular state or territory might consider that they have a major need for someone who is in cabinet making or in a particular form of engineering or medicine, nursing, so forth. The person applies, whether from overseas or in Australia, and they are granted a permanent visa to come and live in Australia. So that's the permanent program. 190,000 people, in fact, is quite a small number when compared to the total number of temporary residents who are in Australia at any time. And as I mentioned before, those permanent places are picked from both the temporary residents in Australia as well as people who are overseas, and some of whom may never have been to Australia before. 2.1 million temporary visa holders at last count. That number has dropped somewhat due to the coronavirus and a number of people returning home, but it remains quite high. You'll see there of the statistics on the screen, the largest cohort is in fact New Zealand citizens who enter Australia on what's called a special category 444 visa. They are often, or many of the people in that cohort have been in Australia for many years, some for well over a decade. And interestingly, many New Zealanders don't really recognize or understand perhaps the full consequences of their visa being a temporary visa. And unfortunately, there are very limited pathways for most of these temporary residents to become Australian citizens. In most cases, the pathways are very similar to those that are there for other migrants. And the knock-on of that seems to be that a lot of people who are here a long time later learn when, unfortunately, when need comes knocking, they don't necessarily have access to the full range of welfare benefits or other social supports that Australians do. The next largest category, depending on how you're looking at it, is the visitor visa category. Obviously, that fluctuates throughout the year. You can see the dips and the troughs over the summer period. And likewise, the next line, the orange line, is the student visa cohort, which is more stable than the visitor visas, but in the opposite sense, the numbers drop down over the summer holiday period and then rise back up during the semester. And at the moment, we have just under 550,000 student visa holders in Australia. The number is probably a little bit lower now, as I say, due to the pandemic, but that is a significant number. And interestingly, when people talk about the temporary skilled visa programs, the numbers are actually quite low. So the number of temporary skilled visa holders is typically around 150,000. That includes family members. And then you have other categories, such as the working holiday visa holders, who have trended around 150,000 now for some time, as well as this category of other, which includes things like the temporary graduate program, which is a program that people can access after they've completed a substantial amount of study in Australia and gives them access to 2, 3, 4 years of work rights to gain experience and live in Australia for some time. So all combined, 2.1 million, and all of them have different work rights, and the employer consequently has different obligations when looking at what sort of employment they can or can't offer an individual in this situation. So they're just another breakdown of how those groups are made up. Interesting to note in this one that the bridging visa cohort is a very high number at this point in time. That's increased substantially over the last decade. Bridging visa holders are people who are in Australia because they are either between two visa applications. So they may have entered Australia initially, for example, on a student visa, fallen in love and entered a relationship with an Australian citizen or permanent resident, lodged a partner visa application, and then their previous visa has expired and they've gone on to a bridging visa, which allows them to remain lawfully in Australia until a decision is made. Now, because partner visa processing is taking up to 24 months in some cases, that could mean that people are on those bridging visas for an extended period. Other people might be on bridging visas because of appeals to tribunals or appeals to the courts because their original application was refused, or a few different other sort of scenarios. But that number is very high. And one of the things about bridging visa holders is, unlike most of the other categories, bridging visa holders' rights to work will vary from individual to individual based on their circumstances, based on the visa they've applied for, and based on their previous status. So that's a really great example, I think, of how not only are there differing obligations between the types of visas that people have, but even in one cohort, you can have a very different range of obligations towards individuals. So just as a bit of a background, why is immigration of significance to Australian organisations? Well, I think organisations in Australia use immigration for two principal purposes. The first is strategic and the second is operational. And invariably there is some degree of overlap in those two classifications, but I think it's useful to think of it in those two categories. Strategic is, in my opinion, where migration is used to achieve a clear business goal that is intended to give the business an edge over the competition, that's intended to deliver critical projects in, say, a time-limited fashion. So it may not be in an area that is the business's standard operations, but you're implementing an IT project, you need critical resources to come in and assist to deliver on that project. or they may be bringing in critical skills for another reason that your business has a strategic need. Operational, as I say, there is some overlap, but from my perspective, often operational roles will be frontline positions. So they may be positions that are taken up during the peak season over the Christmas period in retail, where there is a significant fluctuation in the number of employees who are required. There may also be intra-company transfers. So in many multinationals, it's often taken for granted that people in certain positions will be moved from one part of the company to another internationally. That may be for upskilling. It may be to fill a gap in the local labour market or in the local business, or it may be for a whole range of different reasons. Appointment of a new CEO, could be anything. And then finally, the fluctuating demand. So they're not necessarily clearly separatable, but I think there are two strands there that drive business use. And I think what we recognize is that when we think about immigration in that way, we're looking at both a very highly skilled role, which is more typically going to be filled by an employer-sponsored position. So the business might sponsor for a hospital, for example, they might sponsor a medical specialist from overseas to come to Australia because they can't get someone to work in a particular regional area, for example, or there may be a critical project that's going through, and either the organisation or one of its suppliers, for example, may bring in someone who has skills in that software product, which just can't be found in Australia. From an operational perspective, I think as often as not, those roles are recruited from the local labour market, but because of the substantial number of temporary residents locally, you end up coming across people who are visa holders. And I think what's clear is that with the number of temporary migrants in Australia and with the fact the Australian labour market is so small, it is really important for many businesses to be able to secure people for one or both of those roles. And what's really important here is that breaches of immigration law can mean that organisations don't have the ability to access sponsored visas. Non-compliance with immigration can result in cancellation of sponsorship, bar of sponsorship. And so it's very important for strategic and sometimes operational reasons that organisations maintain compliance, because achieving goals in business is challenging at all times. But when you can't get critical people because you can't use the immigration program, then that is a really major problem. And likewise for multinationals, the idea that you can't bring someone across from the US head office or the Chinese head office or whatever it might be can be hugely damaging and a major problem. So those are some of the reasons that organisations use immigration in Australia at this point in time. But what does the legislative regime look like? Well, immigration law in Australia is governed by the Migration Act and the migration regulations. And overall, the purpose of the Act and the regulations is to control the movement of non-citizens into and out of Australia. And as part of that, Australia operates a universal visa system, which just simply means that everyone who comes into Australia has to have an authorisation granted through the Act and the regulations. Now, there's very few countries overseas. Europe might be a really good example, but there are not too many countries overseas that allow the free movement of people back and forth without a visa. But perhaps what's more common is for people to have visa waivers. You might not actually get a visa, so to speak. You might just get a waiver. For example, when Australians go to the US, you can often get an ESTA, which is not actually a visa. It's a visa waiver product, but it's still a form of authorization that allows you to enter the country. Australia, on the other hand, requires that everyone gets one. And as part of that process, the government controls your rights and obligations when you enter. And that's where you come into this idea that each visa has obligations, or conditions is the term in the regulations. So each visa has conditions, and the individual must comply with those conditions or their visa may be cancelled and they may be barred from returning to Australia. Likewise, organisations must understand the conditions in order to offer employment to the appropriate people and in order to ensure that they're not breaching any immigration laws. So there are three major compliance regimes within the Act, and these are found in Part 2, Division 12, Subdivision C. This particular subdivision relates to the rights of individuals to work in Australia and makes it penalises, makes it unlawful employment of people who don't have work rights or don't have the right or who don't have a visa at all. The second regime, Part 2, Division 12, Subdivision D, relates to prohibitions around people who have sponsored visas. And this is often referred to as charging for a migration outcome, which was the title of the amending Act. And it prohibits people from giving, receiving, asking for, or offering a benefit in exchange for sponsorship. So essentially, it prohibits the quid pro quo around sponsorships and visas so that people aren't abusing the visa system. Obviously, the government wants people to only hire someone on a sponsored visa where they are the most suitable person for the role. And so giving someone else a benefit in exchange for sponsorship is obviously perverting the underlying purpose there. And so there are penalties around that type of conduct. And the final one is the sponsorship obligations. Now, this relates to organisations who have entered into an agreement to sponsor skilled visa holders from overseas from coming to come into Australia. Those people may actually already be in Australia or they may be overseas, but there are a range of different types of sponsorship. So there is what's generally called a standard business sponsorship, which allows organisations to sponsor people for the 482 visa. There are activity sponsorships, which allow organisations to sponsor people for the purposes of training, research, and other types of activities such as entertainment to come to Australia and perform activities within the scope of the visa. There are also more bespoke agreements such as labour agreements, which can be negotiated with the government. But each of these sponsorship types comes with a set of obligations, and those obligations prescribe what the organisation can and cannot do. Things such as requiring the organisation to keep records about the person's employment conditions, records about the type of role a person's performing, their start date, their end date. The obligations also require the organisation to notify the department of various events, notify the department if the salary changes or if there's a change to the duties or if the person ceases work. So these are obligations which the organisation must comply with. Often they are fairly basic obligations in terms of they're not complex activities or sophisticated activities. The problem is for many organisations that you need effective systems and processes to follow this through, and you need HR systems often which are capable of tracking the level of detail and the level of information, and you need stakeholders who are trained to understand these issues. You need stakeholders who are looking out for the issues and then following through internally to make sure that that notification happens or to make sure that records are kept, or whatever it may be. And failure to do so can result in the sponsorship being cancelled, the bar placing a bar on future sponsorships, and potentially even cancellation of visas of the visa holders in some circumstances. So as discussed before, where organisations rely on visas for critical roles within the business, it's really important to understand and comply with sponsorship obligations. Now, the current regime around work by non-citizens was introduced in the 2013 amendment, Reform of Employer Sanctions Act. And this really tightened up some of those obligations on employers to ensure that they are only employing people who have the right to work in Australia. So it reinforced those obligations, and it created an obligation on employers to check that everyone in the business has the right to work. Now, interestingly, that does not just cover new people who are going to enter your business going forward. It covers everyone who is actually already an employee or contractor of your business. So some organizations have taken steps to go back and audit everyone in the business. Other organizations have been much more hesitant to do so, fearing that they don't want to upset some key people in the business, people who may have been there for an extended period of time. Despite that, the law does not actually allow for an exemption where people have been with the business for an extended period. And it is possible, it is always possible, that some people in the business do not hold a relevant visa or work rights. And just by way of an example, there are a large number of people who came to Australia in the 1960s who may have come as children, who had a visa at the time or some other form of permission to enter at the time. And at some stage in the past, that lapsed. And because they had grown up from their own living memory in Australia, they knew that their mum or dad or both were from overseas, but they never really thought about their own status. And it might not come about until they try to apply for a passport, for example, that they realise that they have never in fact obtained Australian citizenship. And so in those sort of circumstances, it may be that there are people in the business who are unlawful. So that's one example of where someone might be unlawful on purely an accidental basis, so to speak, or without knowledge. There are other examples of people who have faked their visa approval letters, or who have pretended to be someone else and adopted another identity. So it's certain and clear that there are a number of people, probably around 50,000 at this point in time in Australia, who are overstaying their current visa. And organisations have to ensure that everyone, current and future, who comes into the business has the right to work. And there is really only one, there's one prescribed list of ways in which organisations can check, and failure to comply with that prescribed list of actions can lead the business to be liable. So if you haven't asked people for their Australian passport or relevant documents, and it turns out the person is unlawful and you've been employing them for an extended period, then the organisation is in breach, and there may be civil penalties and even criminal sanctions depending on the situation. It's also interesting that there are accessorial liability elements here, because this can extend not just to your employees, but also to your contractors. So people who have been engaged on a temporary basis, potentially even through a third party, who are then employed on your site, you may have some obligation to ensure that they have the right to work in Australia. And as a result, there are supply chain impacts. So examples might be where the business has outsourced IT operations, or even outsourced something like trolley collection on the site. There may be obligations to ensure that people who are working on the site, who are within that accessorial liability chain, have the relevant right to work in Australia. And then, of course, the organisation has to maintain records of those checks in order to defend against any future issues which may arise. So it is a strict liability offence, and that means the only defence which can be raised is that the business took reasonable steps at a reasonable time. Now, reasonable steps is defined, and it's defined as using the VIVO system, which is the Department of Home Affairs online visa entitlement verification online system. So essentially taking the person's passport, getting their written authority, entering those details into the computer system, and getting a report back. Alternatively, you can engage a third-party service provider, such as Hammond Taylor, to provide those services for you on a regular basis, or simply on engagement of a visa holder. You can cite a New Zealand or an Australian passport that is deemed to be sufficient as evidence that the person has the right to work in Australia. And interestingly, with that form of that step, that reasonable step, and the reasonable steps that follow, there is no time frame. So you can cite someone's evidence that they are a permanent resident, and even if they cease to be a permanent resident in the future, which is possible because people's visas can be cancelled if there is a criminal issue or for several other reasons, then you don't have any liability because you took a reasonable step, hopefully at the reasonable time, to ensure that the person has work rights. Now, reasonable time is not defined in the Act or the regulations, and I think that is perhaps the most interesting component of this little element of the regime. Now, when it comes to a New Zealand citizen, an Australian citizen, or permanent resident, it is likely that reasonable time means prior to engagement or even on engagement, provided that you haven't actually paid the person to work before you take that step. On the other hand, for a temporary visa holder, it is likely to be prior to engagement and then, in my opinion, every 3 months after that time. And once you have a pool of temporary residents, realistically, you should be checking every 90 days to ensure that their visa has not lapsed. Now, that may seem extreme, but given that this is the only defense against this potential area of liability, I think that 90 days is quite reasonable, particularly because it can be done without a huge amount of effort. And in my opinion, if you go much beyond the 90 days, then there is some doubts around the reasonable time. Now, there are other things that you can do. And what I mean by that is that you can require employees to notify you of a change of their visa status in their contract of employment. Okay, you can make that a condition of employment, but ultimately, if the employee doesn't comply and an inspector from the Department of Home Affairs or the Fair Work Ombudsman, who are also inspectors for the purposes of immigration, comes along and an audit or a monitoring activity picks this up, the fact that you are still employing them, even though the person was in breach of their conditions, means that you are still liable. Okay, so moving on from that particular area, the penalties in this particular section are quite significant. As you'll see, allowing an unlawful non-citizen to work, the criminal penalty is 2 years imprisonment, up to 2 years imprisonment, and the civil penalty is 90 penalty units per offence. And this is one of those areas where employing a person for an ongoing period, you're not likely to be only subject to a single penalty, but potentially multiple penalties. And there is an equivalent penalty for allowing the first one was an unlawful non-citizen, so someone who doesn't have a visa at all. And the second one under 245 AC is allowing a lawful non-citizen, so someone who does have a visa, but is then working in breach of their work conditions. So as we discussed before, different visas, different conditions. So on the 417, it's a maximum of 6 months with any given employer. For most student visa holders, it's a maximum of 40 hours a fortnight. And then there are other regimes for different types of visas. So if you're not complying with that and you're employing a student visa holder who's working 30 hours a week, which is in excess of the 40 hours a fortnight, then you're potentially in breach of Section 245 AC. Now, interestingly, there is also an aggravated offence in this area that relates to exploitation. I don't think it's going to affect anyone in this cohort, but where there is also exploitation of the individual, the criminal penalty increases to 5 years. And perhaps of most significance for many businesses, there is an extension of liability here to executive officers. And executive officers is defined in the Act as CEOs, CFOs, company directors, and company secretaries. And these executive officers can be liable where the body corporate commits an offence and the executive officer was reckless or negligent as to whether the work-related offence would be committed and was in a position to influence the conduct of the body, and failed to take all reasonable steps to prevent the work-related offence being committed. Now, reasonable steps are set out as the actions that the officer took towards ensuring the body's employees, agents, and contractors had a reasonable knowledge and understanding of the requirements to comply insofar as those requirements affected the employees, agents, and contractors concerned. So, of course, there is a different level of expectation required for people who are in HR, people who are in senior managerial roles, people who are line managers, versus someone who is a client-facing individual who may have no role in hiring or firing people. But that said, the officer must ensure that there is some form of training, so reasonable knowledge and understanding of the requirements. So that imposes an obligation, in my opinion, on the organisation to provide training to relevant people to ensure that they understand what they can and they cannot do. And then the second element in terms of the reasonable steps is whatever action the officer took after they became aware that the offence was being committed. Okay, and this is where, of course, you can get into the territory of aggravated offences if the conduct is ignored and potentially even worsened. The criminal offence there is 1/5 of a maximum pecuniary penalty, and the civil penalty is 90 penalty units. So that's your first regime around employing people who don't have the right to work in Australia. And the second regime is this charging for a migration outcome legislation, which came through in 2015. As I said before, it created a penalty for offering, giving, accepting, or receiving a benefit in exchange for a migration outcome. Now, for employers and employees, the accepting and accepting or receiving are the most relevant. And interestingly, this penalty or this regime applies even where the sponsorship does not eventuate or where an offer was made, acceptance occurred, but there was never any follow through. So there is no requirement for it to be the actual receipt of a benefit. It is an or offence there, and so accepting is sufficient to bring you into unlawful conduct. And benefit is very widely defined. So valuable consideration, a deduction, a real or personal property, an advantage, a service, a gift. So thinking about what might occur in an organisation, this is not just the scenario where a line manager says, okay, I'll hire you and we'll sponsor you for the visa, and in exchange, we will give you, sorry, you must give me a brown paper bag full of money. There are much more nuanced situations which might give rise to these type of issues. So an example might be in a hospitality environment, for example, where a manager, line manager, says to a person who's seeking visa sponsorship, yes, we'll sponsor you to be our restaurant manager, but you have to pick up all those Sunday afternoon shifts that no one else in the business wants to do. Now, that may be considered a service in respect of which the sponsored visa holder is giving that particular manager or the organisation a benefit. Okay, so the benefit in that case would be that the shifts that the manager had all that trouble filling has now been resolved, and the visa holder is in effect doing something of a favour for the hiring manager. So it's not just cases of flagrant corruption or flagrant law breaking. There can also be a whole range of much more nuanced and potentially issues which don't raise the hackles of someone in business, but can be interpreted as being a benefit in this context. And then sponsorship event, of course, means just the fact of being sponsored, the fact of being employed as a visa holder, the fact of being hired. Now, the penalties for the individuals involved, so the person who is actually breaching the conduct, is quite significant. So for people who ask or receive a benefit, The penalty can be up to 2 years imprisonment or 360 penalty units, which is $75,000. The civil penalty, which as we all know has a much lower threshold in terms of evidence and prosecution, 240 penalty units. And then again, in this area of migration law, there is also liability for executive officers. And that includes where they were reckless or negligent and failed to take all reasonable steps. Criminal penalty, 360 penalty units, so substantially steeper than the previous regime. And the civil penalty is 240 penalty units, which is $50,000. Now, this liability for executive officers essentially mirrors the previous provisions. It is a case of where the individual was reckless or negligent as to whether the offence would be committed and whether they were in a position to influence that conduct and then failed to do so. So that set of requirements is essentially the same as the previous one. And really, it gives a fairly clear outline of how the organisation can go about mitigating the risk. But of course, as with any area of compliance, it's essential to understand that the area exists, the obligation exists, and ensure that appropriate systems and processes are in place to train people to understand that. And then reasonable actions, the requirements are the same as the previous regime. So what steps did the executive officer take to ensure that the employees, agents and contractors had reasonable knowledge and understanding of the requirements to comply insofar as those requirements affected those individuals. So it is quite important to ensure that the processes and systems are there in place. One thing that we often see in Australia is that in-house counsel is not deeply involved in immigration matters. Often in-house counsel is more focused on commercial matters or governance matters, and some of these workforce issues are left to HR to some extent. I think what we've seen in places like the US is certainly that in-house counsel is becoming more involved, probably due to the scope and the level of the penalties. I know that having spoken to a colleague in Austria, penalties in this type of area in Austria are in the millions of euros. So employing someone who doesn't have the right can result in a penalty of 5 to 10 million euros. And of course, that sort of financial penalty sharpens everyone's interest. In Australia, I think that in-house counsel have a role to play, at least in ensuring that the organisation has the right systems and processes, and then dropping in periodically to make sure that those are being followed. Now, the sponsorship arrangements, as discussed before, this is for sponsored work visas, the 482 work visa, the 408 activity visa. The penalties in this area are principally around loss of access to those programs. There are some financial penalties, however, they are not significant and they do not often arise. There's also this more significant area of a breach of these arrangements, making the strategic and operational goals of the organisation more difficult. If you cannot get that critical person from Sweden or from the US or from wherever to provide that service, to work on that machine, whatever it may be, that is going to make life much more difficult for your organisation. So mitigation, how do organisations go about ensuring that they are effectively limiting their liability and managing their risk? Well, I think that you need to think about how far does our accessorial liability stretch. The laws restricting non-citizens from working, contrary to their conditions, create a number of accessorial risks. These are also inherent in areas that the business may not be typically thinking about. So, for example, does the organisation always ensure that there are requirements in their commercial contracts for the contracting party to check that the visa holders or check that employees in their organisation who may be working on your business site have the relevant work rights. What does it mean for project work? So if you engage an offshore contractor, or if you engage any organisation to come and provide services within your business, are you ensuring that they have the right visas? What about your own on-hire labour agreements? What about when you engage short-term contractors, or what about when you engage temps? You know, are there steps being put in place? Are there processes there to ensure that the other party has responsibility for that? Or what steps are in place on your side to ensure that people who enter one of your sites have the relevant work rights? And then, of course, I think finally for franchisees, so people who operate franchise organizations, I think there's a lot of not necessarily direct liability in this area, but there's a huge amount of reputational risk. And we saw that with 7-Eleven, the failure to manage the risk inherent in franchise arrangements can give rise to some really problematic issues. So what sort of framework does a franchise or have in place to ensure that franchisees are compliant with immigration laws? And if they are non-compliant, what are the arrangements for regularising that? So there's a whole bunch of things that I think businesses can go away and really focus on putting into place in their organisation, updating templates, making sure that checklists just include immigration as a factor to be considered in order to be properly managing that risk. So back on the issue of reputational damage, I think whilst the financial penalties in this area are significant, the reality is there is not a huge amount of prosecution in this area. Prosecution is challenging for the government in this area. They don't allocate a huge amount of resources to it. That said, obviously the civil penalty regimes operate in a different way, and there's much less resource intensive for the government to follow through. But to my mind, the bigger issue is going to be reputational damage. I think there are certain brands which have become bywords for immigration scandals in Australia in the last decade. And I think that what we see in those cases is that organisations may have had some awareness or may have chosen to look the other way as to the challenges posed by immigration. And as with so many of these things, the misconduct has sort of crept through the business in various ways. And one of the things about immigration scandals is they are like catnip for the media. They are often quite scandalous, and they attract a lot of headlines for a long period of time. In my opinion, this is probably one of the biggest reasons that immigration compliance should be on people's radars. We saw earlier this year and in 2019 how the underpayment scandal, for example, really affected a number of businesses who had thought one way or another that there was minimal risk in what was occurring. And I think that we also need to recognise in a space like immigration compliance, any non-compliance today may be the headline in the newspaper in 2 years' time, in 5 years' time. So organisations need to get their house in order now. They need to understand the way that immigration can bring the company into disrepute and address that, get on the front foot before there is any potential problem. So the ways to do that, the same as any other area: appropriate policy, procedures and training. Ensure that there is audit and review into your visa holder population, into your employee population, but also audit and review of your own systems and processes, and ensure that key people in your business have access to the relevant information about immigration law in order to ensure that those processes and systems are working and that they are up to date with the law, because immigration laws change very frequently. Alternatively, if you do not have the resources to do so, then allocate funds to ensure that you can engage a reputable provider who is able to come on board and conduct audits, whether it's annually or semi-regularly, whatever it might be. And ensure that, as we said before, your other templates in the business, your risk matrix, address immigration issues. And I think finally, I would also encourage any organisation that has a response management plan to ensure that immigration is one of the items on there. So in a response management plan, you're obviously looking at the whole spectrum of different issues that can come about in a business. And I think that realistically, immigration non-compliance is one of those areas, because it hasn't happened yet, but the risk of a scenario blowing up should a large organisation be involved is real, and the potential there for businesses is significant long-term damage to the brand. So in conclusion, I think that immigration law obligations are something that many Australian businesses haven't really focused on in the past, and certainly haven't focused on in recent times as an area for risk and liability. I think that the underpayment scandal in particular showed us that it's really critical for businesses to do so, because even though it may appear the compliance environment at this point may appear relatively calm, relatively stable, and relatively favourable to business, that does not mean it will remain so in the future. In fact, it can become very, very voluble very quickly. And think about, if those risks came to fruition, how do you address them? What's the emergency plan? What's our risk matrix? How are we going to deal with things? And just finally, in the context of the COVID-19 pandemic, we will be in an environment where temporary migration and possibly permanent migration are very much depressed for the next 12 to 24 months. Think about how migration plays a role in your business and how you might manage the situation if you can't get critical skills from overseas. Is the business going to invest in training up Australians? Are there backup plans to fill some of those roles if there isn't access to people from overseas? So in conclusion, I want to thank you for attending the webinar. I hope that was of benefit. Hammond Taylor actually provide a range of online compliance tools, including online compliance training, a knowledge base for stakeholders to manage visa obligations and so forth. If that's of interest, please feel free to reach out and contact me. But in any event, all the best with managing your immigration program, and signing off for now. Thank you very much.